Imagine this scenario. A central agency raids a location, seizes commercial quantity, narcotics, commercial quantity, and it subsequently arrests a suspect. Now, inside the interrogation room, the suspect signs a detailed handwritten confession admitting to everything. Under standard laws, a confession to a police officer is completely inadmissible. The current legal practice in India is like this, that under Section 25 of old Indian Evidence Act, a confession to a police officer is completely inadmissible. But what if a person recording it is not a traditional police officer? What if they are an intelligence officers from NCB, customs, or the DRI? For decades, these agencies successfully argued in courts that they weren't the police officers under the law, making those confessions enough to jail someone for 10 to 20 years. But everything changed with one historic Supreme Court ruling. And today we are going to break down Section 53 of NDPS Act and that historic judgment, that is the landmark Tufan Singh versus State of Tamil Nadu judgment that stripped these agencies of these biggest uh, shortcuts. To understand this shift, let's first look at what Section 53 actually says. As you know, that NDPS Act is a special legislation, and under normal circumstances, only state police officers can register an FIR and investigate a crime. Only state police officers, because police is a state subject as per the constitution. So, state police officers, only they can, you know, register FIR and investigate a case. But this drug trafficking, it doesn't care about the state borders. It is an international and interstate menace. So that's where Section 53 comes into play. And it gives the power to the center and the state government to invest officers of other specialized department with the power of an officer in charge of a police station, popularly known as SHO. That this section empowers the state governments and the central government to invest the powers of SHOs to the officers of other specialized departments. So now let's look at the section 53, subsection 1. So section 53, subsection 1, it says that central government can empower officers from central excise, narcotics, that is NCB, customs, and DRI, or even the officers of the paramilitary and the armed forces. And in the same way, under Section 53, subsection 2 of the NDPS Act, the state government can do the same for officers in state excise, revenue, and drug control department. They can be given the powers of the station house officers, that is the officer in charge of a police station. And now these officers can uh, search, seize, arrest, and fully investigate any offense related to NDPS Act. So this power is given to these officers through Section 53 of the NDPS Act. Now, now here is where the massive legal loophole existed. Under regular criminal law, specifically Section 25 of the old Indian Evidence Act, which is now carried forward under the new Bharatiya Sakshi Adhiniyam, any confession made to a police officer is completely inadmissible in court. Why? Because the law assumes that physical force, torture, or coercion could be used to extract confession in custody. It could be a forceful confession. And as the constitution says that we can, in criminal justice system, we cannot uh, have self-incriminating evidences. So the confession can be obtained through um, force, coercion, or torture. However, the central agencies like NCB used to record confession under Section 67 of NDPS Act, which allows them to call for information during inquiry. They argued They argued in the court that look, Section 53 gives us the investigative powers of a police officer. Section 53 gives us only the power of investigation of a police officer, but it explicitly says that we are the police officers. So we are not the police officers, we are the normal officers. We are specially empowered officers under NDPS Act, and we are not the police officers. Hence, Section 25 of the old Indian Evidence Act is not applicable on us. And any confession done before us must be admissible in the court of law. Then this dispute reached the three-judge bench of the Supreme Court in Tufan Singh versus State of Tamil Nadu. And on October 29, 2020, the Supreme Court delivered a monumental 2-1 majority verdict. The court held that if an officer is given all powers of an SHO under Section 53 of NDPS Act, including the power to investigate, arrest, and file a final complaint equivalent to the charge sheet, then that officer must be considered a police officer. And then Section 25 will be applicable to those officers also. The confessions done before these officers will not be the substantive evidence against the accused. And conviction cannot be solely based on these confessions. Hence, if any confession is made in writing before these officers by an accused, then these confessions will be admissible only when any fact or thing is recovered with respect to that confession. Otherwise, they will not be admissible in the court of law. So it will be exactly like the old Section 27 of the Indian Evidence Act, which says that only that part of the statement given before a police officer is admissible in the court of law with respect to which some recovery of a fact or thing is done by the police officer. So this was the major legal loophole, which was existing there in NDPS Act before Tufan Singh versus State of Tamil Nadu judgment, and this void has been filled now, And now the officers of other departments, they are as good as the police officers.